The U.S. Supreme Court ruled Monday that state prisoners have no constitutional right to present new evidence in federal court to support their claims that they were represented at trial and on appeal in state courts by unqualified or otherwise deficient lawyers. The vote was 6-3, along ideological lines. In 2012, the court ruled that when a state court substantially interferes with a defendant's constitutional right to be represented by counsel, the defendant, with a new lawyer, may appeal to federal court to show that he was denied his right to effective counsel. Back then, the majority was 7-2, with Justice Clarence Thomas in dissent. On Monday, Thomas wrote the majority decision hollowing out that 2012 ruling on behalf of the court's new 6-justice conservative supermajority. He said that federal courts may not hear new evidence obtained after conviction to show how deficient the trial or appellate lawyer in state court was. To allow such evidence to be presented in federal court, he said, encourages prisoners to sandbag state courts, depriving the states of the finality that is essential to both the retributive and deterrent function of criminal law. Writing for the 3 dissenters, Justice Sonia Sotomayor called. Today, however, the court hamstrings the federal court's authority to safeguard that right. University of Michigan law professor Leah Litman sums up the decision this way: basically, you can have a federal court hear the claim, you just can't present any evidence to support that claim because Congress. She pointed to one of the cases before the court as illustrative. The defendant, Barry Jones, was sentenced to death for the brutal sexual assault and killing of a 4-year-old girl. But his court-appointed trial court lawyer did not investigate the facts of the case. Arizona law does not allow the first post-conviction appeal to raise the question of ineffective assistance of counsel, and on the second appeal, the appellate lawyer did not raise the question either. Only when federal public defenders were brought into the case for a federal court hearing, did they examine the medical evidence, and consult experts who later testified that the injuries inflicted on the child occurred not when the prosecution claimed, but at a time when Jones was nowhere near the. The federal judge hearing the case found that both the defense lawyer at trial, and the appellate lawyer in state court had provided ineffective assistance of counsel.